Welcome to my channel. Please like, comment, and subscribe. In this video, we are going to talk about Admiralty and maritime laws that affect your case. First, the Jones Act. The Jones Act protects seamen on navigable waters who become injured as a result of their employer's negligence while they are in service of a vessel, regardless of whether the injury occurs aboard the vessels or on land. This act requires employers to provide a safe work environment for seamen. The Legal Information Institute, or LLI, of Cornell Law explains that the Merchant Marine Act of 1920, known as the Jones Act, is a federal statute establishing support for the development and maintenance of merchant marine in order to support commercial activity and serve as a naval auxiliary in times of war or national emergency. And then the next, essentially, the Jones Act, designed that the seamen employed on vessels or working on vessels while in port have legal protections while regard to workplace injuries. Seamen covered under this federal law should pursue legal representation by an attorney with a prolific history of successfully dealing with Jones Act cases. Unfortunately, it is common for employers or the responsible party to attempt to minimize a victim's injury or frame the circumstances in a way that limits their liability, reduces the perception of their involvement, or highlights the victim's alleged negligence. Avoid this painful reality by engaging with our maritime law firm before make any decision or statement or take any action that could impact your case and jeopardize any reward you may be entitled to. And then the next is about the Jones Act versus the Longshore and Harbor Workers Compensation Act, or LHWCA. The Jones Act and the Longshore and Harbor Workers Compensation Act, or the LHWCA, provide compensation for work-related injuries sustained by separate categories of maritime workers. The Jones Act covers a master or member of a crew of any vessels, whereas the LHWCA covers the essential maritime workers that work in piers, ports, terminal, and docks, and otherwise sea-related roles without being part of a vessel's permanent crew. The distinction is important as in employing an attorney first in carrying forth complaints for both categories of workers. And then the next is about Death on a High Seas Act. The Death on a High Seas Act protects the families of individuals whose death at sea occurred as the result of a wrongful act or under otherwise negligent circumstances. Death that occurs a certain distance away from or within a U.S. shoreline can be subject to a variety of laws. And, believe it or not, the simple question of the location of the vessels is arguably the most critical component because of the implication regarding the law that applies to claim. And then deaths that occur less than 3 miles from a U.S. shoreline. Individuals should be aware that general wrongful death laws will apply if a passenger or a sea worker is killed while he or she is still within 3 nautical miles of a state shoreline or within U.S. territorial waters. Additionally, if a crew member or seaman who is within 3 nautical miles of a U.S. shoreline dies because of ship owners or employers' negligence, the Jones Act might also be applicable, and such a claim can be filed right along with the general wrongful death claims. And then deaths that occur more than 3 miles from the U.S. shoreline. Many attorneys are often faced with cases that involve deaths that took place more than 3 miles away from a U.S. shoreline. What spouses and family members should know about such deaths is that they are generally covered by the Death on a High Seas Act. Generally, Death on a High Seas Act will apply to all individuals who were killed in accident that took place more than 3 miles out for US shoreline, no matter whether the individual was a maritime worker or not. As a general rule, Death on a High Seas Act is a nasty federal law that dramatically limits the recovery that can be made in a death claim. For example, the Act limits the amount of wrongful death damages that spouses, children, parents, and dependent relatives will be able to recover, and individuals should note that only pecuniary damages will be recoverable under this particular law. Pecuniary damages are those damages that can be quantified in terms of dollar amount. That said, family members will not be able to recover damages for things like loss of companionship or consortium. Having said that, an experienced attorney knows that there are ways to make a substantial recovery in a death claim if done correctly. Loved ones should also be aware that a lawsuit under the Act must be brought within 3 years from the date of the seaman's death. Additionally, in cases involving the wrongful death of a crew member, the decedent's personal representative could choose to bring an action under either General Maritime Wrongful Death laws or under the Death on High Seas Act. And then the next is the law of unseaworthiness. According to the Maryland Law Review, a ship owner has an absolute duty to certain persons working upon his ship to furnish a seaworthy vessels. That is, a ship and its appurtenances be reasonably fit for the intended use. If the ship is unseaworthy, the ship owner is liable for personal injury caused by such unseaworthiness to person to whom the warranty extends. Essentially, an owner and or operator of a ship is responsible to the crew for providing a vessel's fit for a sea travel. If an accident or injury should occur because of the ship owner negligence, the injured party is entitled to seek damages for his or her pain and suffering. The success of these types of claims relies on the victim's representation, specifically their ability to prove that the vessel was unseaworthy. And you can find a maritime lawyer that is capable of compiling the evidence to support this type of claim to prove that the vessel was indeed unseaworthy at the time the incident occurred. I think that's all the information that I can share to you guys. Thank you so much for watching. Don't forget to give like, comment, and subscribe. Bye bye.